Good evening and welcome to the WDSU News Hot Seat. I'm Travers Mackle. Tonight we're talking two big topics in this area. The church sex abuse that's rocking the Catholic Church in this area. We know 57 names of priest and clergy members were released about a week and a half ago. And also another big topic, unanimous jury verdicts. Voters went to the polls last week, and that is now law. Juries have to be unanimous in this state. We have two guests, security expert Mike Kahn and legal analyst Robert Jenkins. Let's start off with the sex abuse that's rocking the Catholic Church right now. The names of 57 priests and clergy members released. We've all talked about this. The names are out there. People have seen them. But moving forward, we'll start with you, Mike. From a law enforcement standpoint, the NOPD said if we get credible information referred to us, or if anybody wants to make an allegation, we're all ears to look into this. We know that one case is under active investigation right now. How hard is this for police to make these cases? Because a lot of these are 20, 30, 40, 50 years ago.
Right. You don't have a lot of the DNA and other things from when the cases happened. There's not areas where you can go back to try and retrieve that. So a lot of it's statements and just putting things together from what the person said and corroborating with where the other person was when it might have happened and if they were in the same area, and then the validity by multiple people saying the same things.
You're very familiar. The NOPD has a cold case division. Is this something that they could dig into or really start looking at, given the fact that they focus on cold cases?
I think, again, it would be prompted by the initial investigation, and then anything they would get subsequent to that investigation that would lead them on to additional information and further investigations. They would then go that route. But it wouldn't all be self-initiated without a complainant and a beginning investigation.
What do you think, Robert? Legally, obviously we know there's been civil litigation, settlements handed out by the Archdiocese here. The matter was referred to Leon Cannizzaro, the DA, who, like the police, said he takes this seriously, and if there is any credible case put forward by police, he'll take it seriously. But from a prosecutor's standpoint, is it a difficult case to make, given the fact that this goes back decades?
It would be very difficult to prosecute these cases based on the fact that you have no physical evidence. It's all hearsay, word against word. So the difficulty for prosecutors is the lack of evidence.
Can they use statements that were made in civil depositions in criminal cases, or is that kind of stuff inadmissible?
It's virtually inadmissible because you have a right to cross-examine those individuals, and most of them have passed, so you don't have any witnesses, so it's very difficult.
Does the district attorney look into this? What do you think about that? Well, let me ask you, should he look into it, and does he look into it?
Well, I believe that he should, and I know the DA very well, and he will, but the fact of the matter is, just like Mike said, no physical evidence.
Is this something, Mike, that police should be proactive on, given the fact that it's something that affects so many parishes, so many communities here in Greater New Orleans? When I say parishes, I mean church parishes here in New Orleans. Is this something that the police should look into?
Absolutely. Again, it starts from you have to have victims that start the original complaint. And once that starts and they initiate that, then the police will do a very thorough investigation, or the best they can with what they have now and who's still alive from these original statements and what they can go back to originally.
14 men of the 57 remain alive today. It's our understanding most of them are elderly, in their 70s, 80s, even 90s. There's no statute of limitation on rape in Louisiana. Is that the charge that they would have to pursue in these cases? Because some other sex crimes do have statute of limitations.
Well, they'd have to pursue the rape charge for sure, because any other thing would fall off. So the problem that they have is not only what they're going to charge them, what evidence they have for the charge.
Is that the same thing, like where this would be a sex crimes case because there is no statute of limitation on rape?
Absolutely, Robert's right. You would have to go with the only crime or the only charge that would still be applicable right now, and that would be rape.
Unfortunately, in these cases, do you deal with a he said, she said, if you will, or in some cases a he said in these cases, because you do have a victim that maybe the Archdiocese settled with, but the burden of proof is so much higher in the criminal system, if you could touch on that.
Correct. It's going to be statements back and forth. It's going to be, again, it's a whole separate trial. So you have to go back to what you can pull up criminally now, what evidence you have that's viable in a courtroom that a jury can look at. So it is much harder on the criminal side than the civil side, in my belief.
Oh, it's very difficult. And the problem is decades have gone by. People have died. So what evidence, like you said, DNA, doesn't exist.
Let's shift gears here and talk about the other topic that we're going to focus on, unanimous jury verdicts For decades in Louisiana, it only had to be 10-2 to send someone to prison for life. It was somewhat of a darling charge of, or a darling tool of prosecutors. They knew, look, if we charge somebody with second-degree murder, it only has to be 10-2. That's a life sentence here in Louisiana. For the overall landscape of the criminal justice system, what are the thoughts of police officers? Do they have anything, do they have any dog in this fight, or they just go out and make arrests, and it's up to prosecutors to prosecute the case?
Well, that's exactly it. You know, the police, it doesn't affect them one way or the other. We still make our cases the same way. They still do the same things and bring it to the DA's office, and the DA's office prosecutes it. So now it's just a fact of that you can't have any holdouts. So the DA's office really has to do a more thorough job. And not that they're not doing it now, but they have to do an even more thorough job of making sure that everyone is in agreement. And you're going to have longer sustained trials and longer jury times when they get the case to get that entire group.
Because let's just use these examples right here. Cardell Hayes, who's now convicted of shooting and killing former NFL football player Will Smith. That jury was 10-2. That would have been a hung jury,
correct,
mistrial, sending him back for a new trial months after the fact. The Joe McKnight case, the man who was convicted of shooting and killing him, Ronald Gasser, was 10-2 as well. Another hung jury mistrial if this current law is in place. So we're now in line with every other southern state, but does it make it more difficult, Robert, for convictions?
Well, it makes it more difficult on the prosecutors because, as you said, it has to be a longer jury process, and you got to get them all to agree on the felony. On the defense standpoint, well, we need this one for that hung jury now. So it makes it easier.
You handle a lot of cases at criminal court
Sure.
as a criminal defense attorney. How many of your cases go 11-1 or 10-2 and somebody's convicted going to jail for a lengthy prison term?
Well over 90%. We always thought that it was improper to have a 10-2 verdict. So this is going to make it much more difficult on prosecutors.
Nobody really fought this. Did that surprise you coming from a law enforcement background? Jeff Landry, the state's attorney general, is really the only person on record opposing this. Even the state's DA's association didn't take a position actively on this, given the roots of this law that goes back to the Jim Crow era. Did it surprise you from a law enforcement standpoint that more people didn't give pushback against this?
No, because like you said, it's from the Jim Crow era. This is something that was very, very antiquated. And even from a law enforcement standpoint, we look at there's us and one other state in the United States that was still doing this. So at that point, we assumed that it was going to go through, and it really is the right thing. And one of the really important things to bring up, too, as Robert stated before, was this isn't retroactive. So as this goes into play January 1, it doesn't affect any of the prior cases.
That's correct.
Right. Talk more about that for people watching this right now. That means if somebody like Cardell Hayes was convicted 10-2, he can't go back and appeal this and say, I didn't have a unanimous jury verdict. I have to have a retrial now.
Not only if you're convicted, arrested before January 1st, 2019, you don't get that opportunity to have that unanimous jury. It goes back to the old law. So you're going to find that many attorneys, defense attorneys, are going to file what we call an equal protection claim, saying that it's unfair to now go back to old ways because they were arrested prior to January 1st.
Moving forward, how do DAs operate under this? Is it just, look, we're going to try the cases the same way, but now we just have to hope that there are no lone holdouts? And to point this out, in the federal system, which y'all are familiar with, they have to be unanimous jury verdicts. So is this just the prosecutors have to make sure everything's buttoned up because you can't have anybody saying no if you want to send somebody to jail for life?
Yeah, so for all felony cases, absolutely. So again, it's going to be longer deliberations. It's going to be more convincing of the juries to get that last person to swing their vote and to be a part of it.
And the jury process is going to take longer in selecting that jury.